Good afternoon. I hope you are not very tired after the lunch and still will be in the position to follow. I will now report again about one judgment which might be very interesting for national judges dealing with state aid. It concerns mainly the overall problematic of decentralization of state aid monitoring and transferring certain functions in this regard to national courts and national judges. If you allow me, I will just check the first three. I cannot find the
remote. There's no remote.
I can work also with. Yes, okay, it's okay, okay. So I will speak about the Eesti Pagar case. Eesti Pagar is an Estonian company, so a company active in a new member state in which the question arises which kind of measures of transferring competencies to national authorities is possible. This is a preliminary ruling case, so something which you as judges can always use. Always if you have questions about the interpretation of primary or secondary EU legislation, you have the possibility to ask the court for its opinion. It is foreseen in Article 267. I mentioned yesterday that that is one of the crucial provisions in regard to control of legality on the level of national judges, which is obligatory for Supreme Court, so for courts which decide in the last instance. And the question concerned is that of the interpretation of a so-called block exemption regulation. I will explain to you what it is about, why it is a measure of decentralization of state aid monitoring, and also some other questions like, for instance, the question how are the rules on prescription or time limitations to be understood and to applied. I will not read out also because actually I should already terminate my presentation before I start, so I will be as short as possible and concentrate on the substance of the case. But even if I try to shorten, it is very important to see, because time and right and law are always in a very complicated, not always in a love relationship. We have to remember the sequence of events which took place in this case. So there was an agreement between Eesti Pagar and another company to acquire some production facilities on toast, on bread. On 29 September, then Eesti Pagar concluded with a company involved in financing, in particular in leasing a contract, according to which it was the leasing company which should acquire the production facilities and then lease them to Eesti Pagar. 24 October 2008, Eesti Pagar submitted to the body in Estonia. I will not try to pronounce the name of that institution. Let's keep it with the EAS, that's much simpler. EAS, an application for state aid. State aid was then granted on 10 March 2009 by this institution. And then just look, almost 4 years later, EAS informed Eesti Pagar that the granting of this aid was illegal because it did not correspond to the provisions of the block exemption regulation, and it therefore has to be recovered. And then, short after, on 8 January 2014, EAS adopted the decision to recover. This is, of course, very important in order to be able to say, first, was there an incentive effect, and that is a crucial point. And second, was there a prescription or a time bearing or a time limit which had to be respected. Now, the case was disputed as being not admissible because anyhow everything was done on the national level by national court, so that was rejected because preliminary ruling questions are in 99.9% of the cases admissible, because it's up to the national judge to decide whether he wants to ask the question or not. Only if it is absolutely excluded that any kind of union law aspect can be treated, only in that case the Court of Justice rejects preliminary ruling requests as being inadmissible. The crucial provision in this case is Article 8, Paragraph 2 of Regulation 800/2008. This is not true because 800/2008 is the new version, but anyhow, the provision says that an aid can only be granted if it has incentive effect. And now the question is, when does it have an incentive effect? And that is only if the application for state aid was presented before work on the project or activity has started. And the question here was, what does this mean? And this is a very important question, in particular because Eesti Pagar's argument was, yes, of course, if you just look back and we look at the sequence of events, it acquired already the facilities and there was already a leasing contract, and only afterwards, in October, the application was presented, so the works already started and were even terminated because the contracts entered into effect immediately when the request for state aid was presented. And this is now a disputed issue, and this is what the court had to decide. The question is quite complicated, but the substance is exactly what I mentioned, namely, is in view of these facts still acceptable that there was an incentive effect? You see now the text of Article 8 of the GBR, and then the court says, yes, what is this decentralization via these block exemption regulations about? And the court says the notification requirement, which is set out in Article 108, second and third paragraph of the treaty, is a fundamental procedural provision in regard to the monitoring of state aid. That means that it has to be respected without exemption. But there is a way to exempt certain measures, and that is foreseen in Article 109. And according to that provision, exceptionally, the Commission might exempt certain types of aid from the notification requirement. But if it does so, only those measures are really exempted which are precisely described and defined in the block exemption regulation. Block exemption regulations are regulations, so that is to say they are of direct and immediate effect in the member states. There is no transposition necessary. If any kind of aid corresponds to the block exemption regulation, then in that case, there is no notification requirement. The court goes further and says, just because this is an exemption to the general obligation to notify aid, of course, it must be interpreted restrictively. What does that mean? That means that, first of all, there could be no margin of appreciation transferred to the member state. Everything must be absolutely clear already on the basis of the block exemption regulation. The margin of appreciation in this case stays with the Commission, and the Commission used this margin of appreciation in assessing complex economic situations itself, and therefore the block exemption regulation must be drafted in a very precise way, not leaving any kind of uncertainties which then have to be interpreted by the member states' authorities. This is actually the substance of the reply to the first question. So no margin of appreciation of member states, and the drafting of the block exemption regulation must be appropriate and precise. Consequently, in this case, the court says the incentive effect did not exist because the wording of Article 8.2 must be interpreted in a strict way. And since in this case it is clear that the application for aid was made after all works were finished, actually, we cannot say that there was incentive effect. The argument of Eesti Pagar in this case was to say, but it was very easy to withdraw from these agreements which they concluded. And the court says that would be already too far-going consideration. The national courts are not allowed to do that. National authorities must stick to the wording. This would be appreciation of complex economic and legal situations, and the member states are not allowed to do that. So let's come to the second question. And that is considering the question whether a recovery in this situation is necessary. We heard already today on several occasions, also in the presentation of Christina, just before lunch, that state aid recovery in the case of unlawful or illegal and incompatible aid is always necessary. That is the logical and natural consequence of a negative decision of the Commission. So in order to save time, I will just come to the next question. Which concerns the issue of, important issue, sorry for having forgotten that, the authorities of the member states, whatever kind of authorities they are, so whether they are courts or administrative bodies, both are covered by the recovery obligation, because in this case it was an administrative body, EAS, which ordered the recovery, and the question was, is also an administrative body covered by the recovery order? And the court follows from Article 108, third paragraph, third phrase, which is the so-called still stand clause, that it obliges all authorities of a member state. So let's come now to the third question, whether Eesti Pagar could have had legitimate expectations that everything is going well and that he has really an enforceable right to obtain the state aid. And in that regard, the court just repeats the standard jurisprudence according to which nobody can have expected legitimate expectations on aid if it is not granted after a positive decision of the Commission. In addition to this standard jurisprudence, the court also says that in regard to legitimate expectations, it is only possible to have them if the competent authority made repeated and coherent, consistent affirmations in that regard and affirmed that there was a right to obtain that. And that is here not the case. The Commission is the competent authority for aid which is not covered by the block exemption regulation, and the Commission didn't make any kind of affirmations or constatations in this regard. Now, the fourth question is a very interesting one for a purely theoretical point of view. There are limitation periods foreseen in national law, and there are limitation periods foreseen in community law. In regard to state aid, there is a limitation period foreseen in Article 17 of the Procedure Regulation. It used to be Regulation 659 from 1999. Now it is foreseen in Regulation 1589 from 2015 in Article 17. Now, in the old version, it was Article 15. And this says that there is a time limitation of 10 years. After 10 years, the Commission cannot order the recovery of aid. And the question here was, does this apply also to EAS in Estonia? Is the time limitation foreseen in the procedural regulation applicable to national authorities? And the court's reply is no. The court apparently considers that time limitations, which are not questions of admissibility. That only concerns whether the right is still existing or not. That apparently seems to be something which is procedural right, because in regard to state aid recovery, member states' authorities and courts only have procedures of the member state to apply, but not substantial provisions. They are not allowed, for instance, to take any decision on compatibility of aid. The problem here with the reply is that the court really considers that time limitations are something which is procedural rights. And why I'm saying that? Because this question is very much disputed in the Court of Justice, and there is no coherent jurisprudence on that at all. There was one case on public procurement, and this is a judgment from 2012, so not very old. In a public procurement case, Европейски динамики case, the Европейски динамики is one of the favorite clients of the Court of Justice of the General Court, being responsible for about 45 applications in total in the last 20 years, almost all of them in the field of public procurement. And in this case, the Commission, which was the opponent, argued that the application of Европейски динамики for compensation for damages is time-barred because the limitation period which is foreseen in primary regulations, namely in the statute of the court in Article 46, is applicable, and therefore after 5 years they cannot do it. And this is something, because it is procedural right, it is of ordre public, so public order, the court has to respect that even if the parties did not mention it. And the court's reply to that, and I will read out just in order to demonstrate that the dispute is real. By contrast, the court has already held that compliance with the limitation period may not be raised by the European Union Court on its own, ex officio, but must be raised by the party affected. In contrast to procedural time limits, the time limitation period in question, by resulting in the extinction of the legal action, is a matter of substantive law. So, if it is really substantive law, then it cannot be procedural law. But here the court departs from the idea that it is procedural, and there is only one possible solution to this contradiction, and that is to say, well, in regard to the substance, it is probably really substantive law. So what is foreseen in Article 17 of the procedural regulation is correct. But it is up to the member states concerned to determine whether a time limitation or a limitation period, as here at stake, is something of procedural law or is it something of substantial law. And now I would be tempted to ask you how is the situation in Romania, but I spoke to Octavia before I came, and I know that this is nothing which has something to do with the period for presenting an application, so it's not a procedural question, but a substantial issue. So the consequence would be that what is said in this judgment in regard to the applicability of limitation periods does not apply in Romania, because in Romania the questions of limitation periods are not questions of procedural law. Therefore, the judgment in Eesti Pagar in regard to the fourth question does not apply in Romania. This is, of course, very problematic. Why? Because it means that instead of harmonizing the applicability of state aid law in the entire Union, with this judgment, the court created an unnecessary and problematic differentiation. Instead of harmonizing, it disharmonized in a certain ways. But there is, of course, something which can help in this situation, namely, even in those member states in which limitation periods are to be considered as being procedural law and therefore up to the member states and then their competencies. They have always to apply and respect two principles, the principle of equivalence and the principle of effectiveness. The principle of effectiveness says it cannot be drafted in a way that it makes it in practical terms impossible to fulfill obligations following from union law. And in regard to the equivalence, the principle says that those provisions which are applicable in regard to union law aspects must be equivalent to those provisions which only apply in regard to national procedures. So no differentiations favoring national situation is allowed. And that is the substance in regard to this question. The fifth question is the question of the necessity to collect interests. And here the court again says, of course, the issue whether interests for the period in which the company was in possession of the illegal incompatible state aid, the recovery order should also cover interests, and then which kind of interests, because for the Commission's procedure it is foreseen that it must be a compound interest rate which is applicable. The question was whether this also applies to the courts and authorities in member states, and the reply of the court is no, the procedural regulation does not apply, as it was already the reply in regard to the question of limitation periods, but, and this is again a repetition, but in applying national provisions on the interest rate, it is important to respect the principles of equivalence and of efficiency, and therefore, in practical terms, national authorities have to apply via this circumventing argumentation the provisions on compound interest rates, so also on interests every year. And that is actually the end. I tried to speed up. I hope that still you could follow my arguments, and I'm happy to answer your question if you have any of them. Thank you.
So you mentioned that for prescription period in Romania, this part of the judgment would not be applicable. But even in such a situation, the Commission could nonetheless take a case and order recovery, even if the national prescription period would have expired. So this was our interpretation of this judgment, that this would not rule out, at least, that the Commission can order itself recovery in such a case. So you mentioned that the principle of equivalence and effectiveness is something that counterbalances this lack of harmonization, but I would add also that the Commission itself can intervene in such a case and find that the aid is incompatible and order its recovery.
Mm-hmm. Well, I think this question is not really to be discussed, because these are two different issues.
Yes, it's just
for the Commission, it is 10 years, and it concerns the administrative procedure of the Commission. So whenever the Commission discovers something, as from that moment, 10 years to impose recovery in a decision addressed to the member state. A possible limitation period in the procedures of the member states applies as from the first moment in which recovery started, which is much, much later than the expiry of the 10 years period applicable for the Commission. So there is no overlap between these periods. One period ended already, either because the period expired, then the Commission can do nothing, or it did not end, and the Commission will adopt a decision. And from that point, from the entry into force of the recovery order of the Commission, eventually limitation periods at the level of member states applied, provided for that these limitation periods are of procedural nature, and they are not of procedural nature in Romania, in Hungary, in Austria, in Germany, and in a number of other cases. But you must understand, in France and Belgium, the situation is different. Their limitation periods are of procedural nature. And as always, these are the superior legal orders. So their issues has to be respected much more than any other member state's legal order. So that is the background of this case, which is again due to the fact, as I explained already yesterday, that our language, working language is French, with the consequence that 70% of the legal secretaries are French, and therefore the legal order of France is considered to be the most European we can imagine.